asked and instructed Mr. Mgomezulu to come and proceed and assist me with the trial within the trial. And on Monday, it was the turn of Magistrate Cronje to testify. And before Magistrate Cronje testified and every other witness that came and testified in this court, Mr. Mgomezulu will be asked by the court for the reasons for objecting to the admissibility of those statements. And the reasons were put to those witnesses. And those reasons included even the constitutional reason that Mr. Baloyi says it was belatedly added in our objections. Now, with that elephant out of the room, my lord, I want us to go through the heads of arguments, and I'd like to apologize to the court for two reasons. One, I see that they are not paginated, they go according to paragraphs, and also, my lord, because of the speed with which they were compiled, there are gremlins that have crept in terms of spelling errors and the like. Now, with respect to the admissibility of Exhibit FF, which will be my paragraph 6, my lord, regarding accused number 1, the objection as was raised, especially in this passage that Mr. Baloyi relied on, indeed does not contain the constitutional ground. And I'd like to put that frankly before this court, but the explanation has been proffered for the reason thereof. Now, the reason for the objection, as was constellated during the trial, my lord, for the admissibility of Exhibit FF for accused number 1 is that the statement was not obtained freely and voluntarily, since the accused person, accused number 1, was assaulted by the police officers who investigated this case. He was threatened with further assaults that should he not sign the pre-prepared statement that was handed to him at Diepkloof by Colonel Mboto, then further assaults will be perpetrated on him. And also, he testified that he was not informed of his constitutional rights from the morning or the day he met Sergeant Mohola at Tembisa, together with Sadiki and Buthelezi, throughout the duration of the day until he is presented at Colonel Rapadu at 21:45 on the 30th of May 2020 in Diepkloof, SAPS. Now, I'm not going to go over the facts regarding the arrest. Suffice also to say, my lord, that accused number 1 disputes the evidence of Mohola and Buthelezi that the police officers that were involved in thank you, my lord. I was just being reminded that I tend to mix Rapadu and Mboto, so I'll be conscious to be aware what I'm talking about here. He disputes that he was arrested by 3 officers, namely Mohola, Buthelezi, and Sadiki. According to the testimony that he proffered in court, is that he was arrested by a large contingent of EMPD SWAT officers in uniform and other police officers in civilian clothing, which he estimated to have been perhaps 8 uniformed and 5 civilian clothed police officers. And the ones that he later came to know their names are Mohola, Sadiki, Buthelezi, Maphumulo, Monareng, Mabena, and Ngamani.
Sorry. Is it a factual statement that he was arrested by 13 police?
It is not factual. That is testimony, my lord. We don't have records to show.
No, just want to. Normally, there should be an arresting officer. You can bring the whole army.
Yes.
But there's an arresting officer. So if there are 13 police, are they all arresting officers? That's all I'm asking.
They all descended on the scene, but it will...
Are they all arresting officers?
I'm coming to that, my lord. It will look like, according to the testimony of Mohola, she was the arresting officer.
Okay, and according to your client?
According to my client, the person that actually affected the arrest was Mapumulo.
Okay, fine.
And then also, my lord, he disputes that there were only two cars, the one driven by Buthelezi and the one that was driven by Mohola. He estimates that there may have been at least 7 cars involved. Now, all the police officers who are involved with the arrest of accused number 1 denied that he was assaulted, and they maintained that stance in the evidence given in court. Now, accused number 1 testified that he was assaulted at Letabong in Tembisa shortly after his arrest. He was then taken to Vosloorus next to a municipality building that houses the court, the police station, and other offices. And further, he was assaulted at Diepkloof. Like I said, my lord, I'm not going to traverse those facts. They are in record. Now we come to Exhibit FF, which is a document labeled Confession and Admission. And it's the document, the pro forma that we have looked at, and the annexure that still has to come, should it come, that was completed by Colonel Mboto. Now that pro forma is Exhibit FF, and it has certain preliminary questions that the commissioned officers must go through with the deponent or the suspect. And amongst those questions, at question 3 is whether or not the deponent has been assaulted or threatened, to which the accused number 1 answered in the negative. Now, question 7.1 of the pro forma, it asks the following question: have you previously made a statement to any police, to any person in respect of this incident? The answer is yes, to the police who arrested me. And then 7.2, if so, to whom, when, and under what circumstances? The answer is under normal circumstances. And then 7.3, why do you wish to repeat the statement? The answer, they told me not to talk in details. They will arrange somebody else to obtain the statement who is not participating in the investigation. Now, my lord, what then is my issue here is that at 7.2, the answer that is given to whom have you given the statement, under what, when, and under what circumstances? The reply thereto is under normal circumstances. I submit, my lord, what the question wanted was the background to how the statement was made to those officers. Where, when, and under what circumstances. And my submission is that Colonel Mboto does not pursue this question further because it's an ambiguous question. He does not elicit what normal conditions the accused is referring to, because contextually, if you say under normal circumstances, it's vague. We submit. And this question, in my view, required Mboto to ask what happened between the police officers that this statement was previously given to. What happened between them and accused number 1 in order for accused number 1 to have agreed to this process of him brought before Colonel Mboto. Now, in further elaboration of this, my lord, and it's a concern that we see regularly when we are involved in matters that involve trials within a trials and admissibility and denials of statements being made, is that prior to a suspect being brought before a commissioned officer, this question will be asked and it will be noted. But then the problem is that when the commissioned officer makes his own statement, it appears on the statement of the commissioned officer that this is a spontaneous answer that was given to me. It has never been given to anyone else. Whereas this answer was elicited before during interrogations that do not form this part, that are not disclosed to that commissioned officer. That, by the way, I was interrogated first by Mohola at Vusimuzi Hostel at the gate, according to her, which is disputed by accused number 1. I was then taken to Litabong, interrogated under coercive circumstances where I was assaulted in the following manner. I was then taken from there to Fospio Ras, where I was further interrogated by Brigadier Gininda in the confines of a car, where I've waited for him for 3 hours in handcuffs that were injuring my wrist. I was swollen. So those circumstances, when you look at this answer, it says normal circumstances. So nothing happened because no response, further response is elicited from the accused person when he says under normal circumstances. Those we submit, my lord, are not normal circumstances. And this is not a spontaneous answer that is given for the first time to the commissioned officer. It's been given to other people under, as we submit, under very coercive circumstances. And also this answer in 7.3, it creates an air of suspicion that accused number 1 was told what to say at Mboto. And I repeat the answer again. He says, they told me not to talk in details. They will arrange somebody else to obtain the statement who is not participating in the investigation. There's an air out there, my lord, of suspicion that what we are told by Brigadier Gininda, that without much ado, you say to accused number 1, I've got a reason that you are a person of interest. And accused number 1 says, yes, I've always wanted to take the monkey off my back without anything further. We submit that cannot be, my lord. Now, at 6.11 of my heads, my lord, we say question 6 deals with whether the accused person had any injuries, if so, of what nature, to which the accused answered as follows. Yes, in both arms I have marks due to the handcuffs that were very tight. And the observation by 6.12 by Colonel Mboto was as follows. I noticed the marks on both hands and I even loosened the clips of the handcuffs. And further, my lord, there's a section where Colonel Mboto, with regard to these injuries, he says, when asked about the nature of the injuries that he saw, he said, I saw red dots of blood and a little bit of swelling on the wrist of accused number 1. Now, my lord, let's take it into context to show how improbable that is. The injuries that Mboto says minimizes by saying there were little drops of blood, a little bit of swelling. Accused number 1 is arrested in Tembisa at around 1:30 on the 30th of May, 1:30 p.m. on the 30th of May 2020. There and then he's handcuffed, and the police officers make sure from then that the handcuffs are tightly squeezed around the wrists of accused number 1. At the time he is presented to Mboto at 21:45 p.m. on the 30th. He has been in those tightly squeezed handcuffs for 8 hours plus. And there's a reason why Mboto says, I loosen them up. He's a police officer. You can see these handcuffs are causing injury, harm, damage to accused number 1. So my submission is that Colonel Mboto, as a police officer, he's minimizing the injuries that he actually observed, because accused number 1 says, my hands were swollen and I was bleeding from my hands. It was not a little bit, it was not little bits of droplets of blood. And my Lord, I'm going to ask the court to take judicial notice of jurisprudence that emanates from the UN regarding the use of handcuffs as a means of torture. And literature says the prolonged use of handcuffs and other restraints is a means of torture. Accused number 1 says, in Tembisa, when I was arrested, made to lie down twice, first time, Maphumulo lifts and leverages me up with the handcuffs that are tightly squeezed. I don't have to be accused number 1 to imagine the excruciating pain when your body is only leveraged. You are lifted up with the handcuffs at your back. And that happened at Tembisa, according to accused number 1, twice, because first time, all 3 of them, the 2 gentlemen that he was with, they were made to lay down. Then they picked accused number 1 up. Who are you? I'm Muzi Sibia. I'm from Kwamatabatini. Lay him down. Pick these ones up. They are not restrained. Whatever happened to them happens to them. He goes on the ground for the second time again. He's leveraged, lifted up with those handcuffs, with his hands at the back. So from there, assault and torture, in this manner, it is my submission, my Lord, begins. Now, as they testify, both accused number 1 and 2 kept on showing the respective interpreters that to this day I still have marks around my wrists. Now, if we minimize that to what Advocate Baloyi said on Friday, that the marks that were there were tantamount to a mark left by a watch, a strap of a watch. I'm wondering, my Lord, what watches are they making these days? What watches with, remember the makeup, my Lord, of the handcuffs. They've got these parts, these serrated parts. They are double layered, these bracelets, double layered, hollow inside. Whenever they are squeezed, my Lord, a number of things will happen. I'm not a medical expert, but any stretch of imagination.
But you are testifying to that now.
The court will take judicial notice, which is common sense.
But you are not arguing that when he was lifted in his cuffs, it was intended to induce him to make a confession.
No. I've
never heard any one of you saying that.
No.
Right.
It's got nothing to do with the making of the statement, yes. But I said from this moment on, the assault starts. Because you are softening up your target for later.
Fine.
Now, also, my Lord, if now, according to Sergeant Muhola and Brigadier Gininda, that having spoken to accused number 1 and having heard that he's cooperating, he is going to make a statement, then, my Lord, it won't make sense that you still keep him on with those handcuffs still tightly squeezed. You loosen them up because now he's working with you. Why will they still be kept tightly squeezed even then?
Was it ever put to Sergeant Mohola, Mohano, Utelezi, Munaring, that you purposefully tightened the handcuffs on accused number 1 and 2? I'm not sure which one. Number 1. In order to torture him and in order to perpetrate an assault. Was it ever put?
That was never put, my lord.
Yeah.
We'll concede to that
It
ready.
was never put. Fine, let's go on.
Yes. Now, also, my lord, this issue of the injuries to the wrists, then it proceeds. Where does it go? It goes to the OBs that were Exhibit NN, in particular, Pretoria North, in the morning, 1:40 a.m., when accused number, not Pretoria North, I'm sorry, my lord, Valeria, SAPS, when accused number 1 is booked. Because now, the cell master will see when the handcuffs are removed from accused number 1, and whether the injuries that he see have got to do with the assault for the statement or the injury by themselves. These are the injuries that somebody who removes the handcuffs, who takes somebody to the cells, will find hard to miss, my lord. So the entry in Exhibit NN that says accused number 1 is received without visible injuries cannot be true, my lord. How can you miss those injuries on the wrist where you remove the handcuffs? Because somebody doesn't go to the cells with the handcuffs. How will you miss that? How will you not note that? Now, the evidence of accused number 1 is that on all 3 occasions where he was assaulted, be it Lethabong, Vosloorus, and Diepkloof SAPS, the main mode of assault was a clear plastic bag covering his face, nose, mouth, up to the neck level so that he cannot breathe, with somebody pulling that plastic bag from behind and somebody holding him so that he doesn't move. And my lord, also the court will berate me that I'm not a medical expert, but with all due respect, my lord, what sort of visible injuries would we expect to see from a plastic bag pulled over somebody's face? And what sort of injuries would we
Well,
see?
he was kicked by 13 men, remember? He was kicked and assaulted, choked, tubed, etc., etc., etc.
My lord, with respect, I think during Mr. Mgomezulu's leading of accused number 1, the court vividly asked, who assaulted you? And the names that accused number 1 mentioned, and offhand, they don't come to me, but I remember he mentioned Mohola, Butelezi, and he never intimated that all 13 participated in the assault. He said they were present. We all drove to Lethabong. We all drove to Vosloorus.
Okay,
but he
fine.
doesn't intimate.
But at least it's more than one.
At least it's more than 1.
Okay, fine, let's go on.
My lord, I also submit that it will be pure speculation and conjecture in the absence of a J88 detailing the injuries, because only a medical expert will detail the injuries that were perpetrated to an accused person who was assaulted in the manner that he alleges. So my submission is that it will be speculation. We don't know how he was kicked, where he was kicked.
Well, we knew he was kicked with booted feet, for instance.
But the pressure, how those kicks were, we
He
don't
says
know.
he was
this.
kicked all over his body.
Yes. And by his own testimony says, the ill effect thereof was, my body was sore all over after this incident, and also whatever feelings he had from the suffocation. My lord.
Sorry, this submission about the J88, what does it concern?
Sorry, my lord.
The J88, you're saying it is only through the agency of a J88 that you can establish what sort of injuries a person sustained.
Yes, my lord.
Is that the law?
My lord, in terms of detailing the injuries to a suspect or a victim, what I know in South Africa is that the person gets taken to a doctor who completes the
Yeah.
J88.
Yes, you must be taken to a doctor
Yes,
after laying a complaint at least.
yes,
Normally,
yes,
because that's the commencement of criminal proceedings.
yes.
Yeah. Mokgotleng says, Ramusipili kicked me, choked me, etc., etc., and I intend laying a complaint.
Yes,
Then the police are going to say to you, fine, make your statement. Thereafter, they take you to the district surgeon or a doctor
yes,
in a hospital.
yes. Yeah, that's the procedure, man.
Yes.
Indeed so.
Okay. Yeah.
Now, also, my lord, we just briefly touch on what, I'm not sure about his rank, Mr. Swanepulu testified in this court about the procedures pertaining to the reporting if there's a complaint of assault or any other abuse, maltreatment of the conditions in which you were caught. My lord, my submission is simply this. The national instruction speaks about an ideal. We are talking about reality. We are talking about South Africa 2023-24. This is not an idealistic world whereby police officers do their jobs according to book.
Is that a serious statement?
My lord, I'll say this with all due respect.
No, but you're referring to all police
No,
in
no,
South
no.
Africa.
Okay,
You're saying this
I'll
is not...
confine.
in 2023, police never use those directives by Sonepol. That's basically your submission.
I'll confine
Because
myself to this
we're
case.
in a different era.
Yes, I'll confine myself to this case and I'll show by
Counter
an
distinction.
example. Yes.
When police murdered Steve Biko, they used to use this directive, for instance. Is that so?
I don't know when this directive was publicized. I don't know even whether human rights were applicable as to the conditions.
Yeah,
of
we
your
know
cell
apartheid
and
was
whatever.
bad, terrible, but there were certain minimum standards applicable.
Unfortunately, I've
That's
never,
why there are the judges' rules.
Yes,
These were formulated in 2014. Is that so, Mr.?
Yes, I think 19.
Sorry,
31, if I'm not
1940,
31. if-
1931.
Yes.
Every policeman had to know the judge's rules. And if you go through the judge's rules,
yes,
they talk about these unlawful acts of assaulting, torturing suspects and detainees and arrestees.
yes, my lord.
1931. Okay, let's proceed, sir.
Thank you, my lord. I mean, that's it. Now, my lord, also the gravamen of the state's complaint against the allegations of assault by accused number 1 and 2 in particular are that no reports were made to, for example, in this case, to Colonel Mboto when the accused had the first opportunity to do so, at Villaria when he was booked in, and at the first court appearance in Tembisa and the like. Now, with respect to Villaria, under the evidence in chief, accused number 1 testified that, in fact, in the morning, he did report to an officer that the persons that brought him, i.e., Mohola Buthelezi and the company that brought accused number 1 in the early hours of the morning, had assaulted him. And that police officer said, okay, I'll go to the registers and check who brought you. And upon perusing the registers, he comes back to accused number 1 and says, listen, this is the National Cold Case Unit. Those people that brought you here are far more superior or senior than me, and I'm paraphrasing there, my lord, so I cannot help you. And the other I've briefly touched on that one, my lord, regarding the J88, is that both suspects, accused number 1 and 2, respectively, showed no visible injuries. We've canvassed that with respect to the procedure that must have been followed, the complaint taken to the doctor, district surgeon, and examination J88 completed. But I'm saying even that, my lord, flies in the face by the fact that at least the injuries to the wrists were so visible that a diligent police officer booking accused number 1 and 2 into the cells or out will notice that, my lord, as the court pleases. For example, my lord, Colonel Mboto says if accused number 1 was brought to him and he says he was assaulted at those 3 places that I've mentioned, the police officers are fit people, he could have made it at this place with an ambulance. Now, my lord, that's a curious statement to make as a police officer. Tacitly, what is he saying? Is he saying we assault but we are sophisticated, we don't do something like this? What is he saying?
No, tacitly he's saying he was never assaulted. That's the only inference you can draw from that remark.
My point is different. Tacitly,
okay, fine.
Yes, he's saying we can assault but we do a better job than this. We don't assault people to a pulp. Now, my lord, we are at a point now where accused number 1 is now interviewed by Colonel Brigadier Gininda at Fosloras, and having spoken to him, and he forms an opinion that what accused number 1 is telling him is something amounting to confessions, he says, to the team of Mohola that was supposed to go to the hostel with accused number 1, that there's been change of plans. We are going to Deep Kloof now, to Colonel, not even Deep Kloof, my lord. He says, I'm going to make arrangements for accused number 1 to see an independent person to take a statement from them. Now, my lord, accused number 1 has testified that he was never taken to Ereton, as the police officers allege. They took him straight to Deep Kloof, where the assaults perpetrated upon him, especially the plastic bag tubing, continued until he agreed to sign the document that was presented to him by Colonel Mboto. Now, my lord, that aspect of Mboto, we've covered it with those paragraphs at the beginning. But what is of essence is that, according to his testimony, accused number 1 says, as they are leaving Deep Kloof, he sees in the parking lot police going to talk to Brigadier Gininda. That is pivotal, my lord, because according to procedures, any member of the investigative team, be it Mohola, be it Mohane, I don't know what the role of Mabena was, the deceased was in this case, and Brigadier Gininda, they are not supposed to be anywhere near the area where the statement or the confessional statement is being obtained from the accused person.
Yeah, Gininda says he was never at Deep Kloof.
Yes, but
he doesn't even know Mboto. Only saw him for the first time on the Tuesday when he went to Innerdale to collect the alleged confession.
Statement. That's
I
correct.
know your
my lord.
client says he was there, fine.
Yes.
But he denies it at least.
As the court places, my lord.
And the other gentlemen, Jonathan and Buthelezi and all those guys, I thought it's common cause that they were escorts.
Yes.
And they don't, according to them, they didn't enter into the room in which the alleged confession was taken. They delivered, according to Jonathan at least, accused number 1 to, no, I'm wrong. I was thinking about, yeah, they delivered accused number 1 to Mboto, and they left at the parking lot there. Subsequently, they say they were called to say the statement has been taken, and they escorted accused number 1, I think, to Valeria or whatever.
My lord, you see, the issue with me is this. These are police officers. They are mandated in their furtherance of their duties because they attend several scenes per day. They are mandated to carry pocketbooks. All we hear is their say-so, their bad denials. I was not there. I did not assault him. We keep on harping back, my lord, to apartheid days, whereby police officers will also employ the same modus operandi. Whenever it comes to matters, all of them, the pocketbooks have grown legs. They are not to be found anywhere. So all the court relies on is the say-so, the ipse dixit of those officers.
Well, they said the unit was disbanded. And of course, even the alleged leader of that unit, Colonel Singh,
Yes.
came to say the same thing.
My lord, I know in SAPS there's what's called SAP stores, SAP 6. Records are kept. These are state records. The unit can be disbanded, the records are not disbanded, my lord. Now, my lord,
But are you seriously alleging that if a policeman assaults a detainee,
yes,
he's going to write in his pocketbook at 6:30 p.m., I assaulted Rata Mokhatle
my lord,
in a pocketbook?
that was the answer that was given by accused number 2 to say.
No, I'm asking
Yes,
on,
yes.
The, on the probabilities.
No, my lord, what I was raising the issue of pocketbooks on is to say, the pocket will say, Ramusepele S, on duty at 6 a.m., attending to scene, 15, whatever,
Yeah, fine,
at this place.
Fine.
We don't have that. All we have is their bad denials and their say-so, my lord. Now, the other issue, my lord, that also perturbs me about the arrest of accused number 1 that I believe we need to address is the incommunicado detention of both accused 1 and 2. Now, accused number 1, my lord, let me go back to this point. He's arrested on a J50 warrant, which is issued in terms of Section 43. The J50 warrant emanates from a Tembisa matter, 217 of 3/2019, which is the dealing in drugs or possession in drugs. And the warrant is issued almost 6 months before it was executed in December of 2019. Now, the police, according to Mokola, they embark on tracing the suspect that they do not find because the case was never placed on record because they need to establish and find the forensic report. Now, miraculously, the warrant is executed on a Saturday, my lord, for that Tembisa matter. And I'll tell the court why it gives the police an advantage to execute that warrant on a Saturday. Because the accused person cannot be taken to court. But what does the law regarding warrants say of arrest? If I'm arrested on a Tembisa matter, be it a Saturday or a Monday, if the court is out of working time, it's after 3 or after 4, whatever the court time knocks off, I must be taken at the police station in Tembisa and be left there alone until I appear in court and the issue of the J50 is ventilated by the court that issued it.
Yeah, you're correct, but you're not quite correct in terms of the law.
Yes, my lord.
I've brought urgent applications 1,000,000 times
Yes, my lord.
of a guy like him being arrested
Yes,
on a Saturday,
yes,
even on a Sunday,
yes,
and you argue that there's no just cause. You sometimes succeed.
yes.
So this statement blanket, hey, when a person is arrested, he can't be taken to court on a Saturday or Sunday. With minimum qualification, you're correct.
Yes.
But we all know that's what you call an urgent application. And I know some 5, maybe they ended it 3 years ago. People could apply for bail even after hours at the Johannesburg Magistrates Court. You know that.
It's still their position.
Still there, Saturday also.
Regarding certain offenses.
There are magistrates who are on standby. Anyway, you've heard me.
Okay, my lord. Now, what I'm saying is, in terms of the J50 warrant, because this one was not an urgent one,
Yeah,
it's
yeah,
been
fine.
sitting with the hands.
No, I
of
take your
the court.
point.
He was supposed to be taken at Tembisa until that warrant is ventilated on the 1st by the court that issued it. And the warrant does not say, take him and gallivant with him and do whatever what you do with him. It's specific.
Say, I listen. I think I listened to evidence which says accused number 2 and number 1 were sought by the police. Actually, through the aegis of the informers. For instance, I'm not prejudging anything.
I'm listening.
Accused number 2 was traced up to phase 2, Rustenburg, Freedom Park.
Yes.
Even Mohola says accused number 1 was also being sought. I don't know, maybe I'm making a mistake. You can correct me, anybody.
It indeed so.
That's the evidence I had.
Accused number 1 was being sought with respect to the Tembisa matter.
Yeah, let's continue.
Yes. Now, my submission, my lord, with respect to this issue of the J50, and I won't leave it lying, is that it is used, my lord, for...
Strategically, like Mr. Mgozi
Yes,
was arguing.
yes. And there's a term for that in law, my lord, where they say you've obtained that J50 from the legis because you obtain it for the Tembisa matter, but when you arrest the accused, you don't ask him anything about the Tembisa matter. You start asking him about the Senze Meiwa murder case. So it was sought and obtained for malafide reasons.
Nefarious reasons.
Yes.
That's Mr. Ngomezulu's language. But did you use that word? Yes. Yes, I listen when people talk.
I would have thought it will be more of Mr. Munisi's.
No, I
Yes.
remember. He said nefarious reasons. Mr. Munisi, we are saying, all right? Let's share the joke.
I think there's a bit of a communication that's going on between my two colleagues here. And then,
Oh, I see, okay.
and then my name just got dropped.
Sorry, Mr. Munisi, for putting you under. Now, my lord, the incident pertaining to the traditional healer, I submit that the aim of this trial within the trial, my lord, is very circumscribed. It's what is called a mini trial. Mr. Lionel Zwane testified in the main case. I'm not going to touch it here because it forms no basis for me doing so here. Now, the other aspect is Exhibit GG, which is the pointing out
Ramaput.
by Lieutenant Colonel Hadebe.
Oh, sorry.
Yes, it's
the-
labeled the notes on the pointing out
Yeah, the
of a
pointing out,
scenes
okay.
and or points. And as well, we say this pro forma has got certain preliminary questions that the commissioned officer must go through with the suspect. And at question 3 thereof, my lord, it says, the question is, what were the exact words of the member of the force when he approached the officer to take charge of such a pointing out? And then the answer is, can you please obtain a pointing out in my case? Now, my lord, I'm going to submit this here, and with all due respect, my lord, this is not codified in any of the procedures of the SAPS, but through practice of the SAPS, in order to sterilize the involvement of the investigating officer and to keep the purity of that confession taking statements or pointings out or admission taking statements, the investigating officer must be far removed even from the arranging part of these procedures to take place.
Alberton. I say he was in Alberton.
Yes.
So he should be somewhere else.
No, I'm not saying he was present there, but him communicating to say to Hadebe, obtain a pointing out in my case.
Where is the Ginanda stationed?
I think at the time he was at Araten, but he also mentioned national office. I'm not sure, man.
So he phones a gentleman in Alberton.
Yes.
You should have phoned a guy in Bloemfontein, for instance.
No. Like I'm saying, my lord, it's not codified in any of the procedures, but it says the investigating officer, once he's got this information that certain of the suspects in the case that he's investigating, he must then phone his commander, for his commander to make the arrangements himself so that the investigating officer does not speak to these people. Because, say for example, my lord, and
I hear you.
I'm leaving it there. He says, I want you to do a pointing out in my case. I wish to be the fly, my lord, between the two walls. What else is he saying to Hadebe that we are not privy to?
Yes, any other thing?
Also, my lord, at paragraph, and my lord, let me take paragraph 9.6 for the question that the judge just asked. Should he call somebody in Bloemfontein, for example? For example, here in paragraph 6, Hadebe testified that he's based in Rustenburg, heading a unit there. So he phones Hadebe, who's got an experience, and Mr. Mnisi said the experience of Mr. Hadebe in taking down of pointing out was in its infancy stage. It was in a nascent stage, because this was only his fifth pointing out. And I'm only putting it there because of what the question that the court has put. But the main one that I want to put is this one, paragraph 3.
Why do people have the concept of an experienced performer or an experienced person? Where does it emanate from? Because how do you acquire experience? You must start somewhere.
Yes.
That's it.
Well, we all
Yes.
started somewhere.
Fine. The first, even if it was the first of his pointing out,
Yes.
was he qualified to do it?
He was qualified.
Was he
But we
trained
saw,
to do it? We don't know.
yes, but we saw
Okay.
the mistakes because of his experience crept in. He mixed up the dates as to when he was called, when the arrangement was made. Corrections had to be made here in court. So
Yes,
experience
yes.
does count.
Okay. Yeah.
Now, at that paragraph 3 that I was going to, the question says, the said was asked whether he was informed of the reason of his arrest as prescribed by Section 35 of Act 108 of 1996. And the answer is, yes, I was informed. I was arrested of drug dealing. Now, that also, my lord, I submit the answer is vague in relation to what Colonel Mboto is called upon to do. Colonel Mboto is not called upon to do a pointing out in respect of a drug-related case. He does not, in his pro forma with a side note, ask edification questions. We know the law says the magistrate...
Which came first, sir?
Or the,
Which came first, the arrest for the drug dealing?
Sorry, my lord, he says, the question says,
Oh, yeah.
The said was asked whether he was informed of the reason for his arrest as prescribed by Section 35
okay,
of
yes,
Section
I hear you.
108.
I hear you.
And the answer is that I was informed, I was arrested for the drug dealing case.
Okay, fine, yeah.
But Hadebe is not ceased with doing a pointing out on a drug dealing case.
What is he seized with? He
Whatever-
doesn't know. If we must be factual, he doesn't know. Can you please do a pointing out for me? The accused is Ratam Khwache.
Yes,
He'll be brought by Inspector
Malou.
Ngomalo. And then Ratam Khwache is brought to Khadeb.
Yes,
Doesn't know the intimacy
of the
and
details.
the contents of the case itself. So you can argue the other way, Mr. Gumezu. Katangazi.
Sorry, my lord.
Let's go on, Mr. I'm going to review all these questions, everything.
All right, my lord.
Any other aspect? you
Yes,
want to
yes, my lord.
close?
I'm just going through my notes. And also this issue of accused number one saying he according to Gininda, he elected to point out, we vehemently and
Yeah.
submit that he said to Gininda that he wanted to point something out. The pointing out scenario came out when Gininda by himself said, I was questioning accused number one whether he wants to make an independent, a statement to an independent officer and further.
No, that's not
whether-
the evidence. The evidence is Mokolejo, who was effecting the arrest of accused
Yes.
number one, allegedly telephoned Gininda
Yes,
to say accused number one,
it's making certain admissions.
yeah, certain
Yes.
admissions.
Yes.
And then Gininda says, okay, wait, go to the First Loras police station. That is the evidence I listened to.
Yes, but didn't Gininda at first Loras himself then interrogate?
Yeah, but you are
accused
giving the impression like it's Gininda who acted on his Meromoto initiative. No, he was advised by a junior
Yes,
officer.
but I've already laid the basis for that.
Okay,
That's why
fine.
when I jump here, I didn't
Okay,
want to lay
fine.
the basis again for
All
that,
right.
my lord. Now, also, my lord, I want to touch briefly on the reporting of the assault now. That will be on the 10th of July 2020 at Tembisa Magistrates Court, my lord. And my lord, we have had a debate even during the giving of evidence that accused number one had instructed his legal representative to say that he was assaulted by the investigating officers of this case. But I'm not going to go against the record of Tembisa, which recorded that the accused says he was assaulted by police, SAPD, Silverton, and that he wants to be transferred to a prison. My lord, what I want to say in respect of this is the following. Whether or not the accused said I was assaulted in Rustenburg in Tembisa, it was incumbent upon the magistrate because they are the overarching overseers of the constitution.
There was an attorney there, remember?
Yes,
And the magistrate, according to the record, told this attorney, you must go and prefer charges. And you know what? If you don't find satisfaction, you must come here. You must come back. That's the record I remember. You remember that, Mr. Mgomezulu?
in Tembisa.
No,
Not in Tembisa.
not in Tembisa, in Boksburg.
It was not in
They are
Tembisa.
fine. There was one of the reports where an attorney made a similar report. You're
It
saying
was
it
in
did.
respect of accused number two, Mr. Nkwana, after the withdrawal of Mr. Mjiako.
Yeah,
in
yeah,
respect
yeah.
of number
That's
two.
Mr. Nkwana. I never made a
Yes.
report.
Yes, but in this one, my lord, with
Which one is
respect
that
to
now?
the 10th of July,
What was happening?
Tembisa,
Which court was it?
Tembisa Magistrates Court, my lord.
Uh-huh.
My submission is that whether accused number one had said to the magistrate, I was even assaulted in Rustenburg, it's incumbent upon the magistrate to investigate the circumstances of that assault, because, my lord, my submission is this. had this point of Silverton SAP had been clarified by the inquiries and investigation by the police officers, the truth of where the assault was perpetrated, who perpetrated that, was going to be raised. More so, my lord, the investigating officer of 2173-2019, Sergeant Mohola, was then in court, but nothing was inquired from her by the magistrate. My lord, I see we are closer to 11:15. May I suggest that we take a short adjournment and I'll proceed after
Yeah, okay.
tea.
Come back at 12:30.